should now render the decisions in the motions by Tricia Watson and David Simpson. The Watson-Simpson team filed a motion on the 9th of September 2022 for several orders and a declaration. The principal orders seem to be that the Commission orders the Barbados Light and Power Company, before the commencement of this hearing, to adjust the depreciation policies and rates used in the application for rate review to reflect the Commission's decisions and orders issued on the 25th of February 2009. Further, for the Barbados Light and Power Company to file an amended depreciation schedules pursuant to the Commission's said decision dated the 25th of February 2009, and to adjust other calculated values that are dependent on the depreciation policy and rates, including but not limited to fixed assets and base income. In its grounds, the Simpson-Watson team observed that the depreciation calculations are a critical component of the revenue requirement, which the Commission agrees with. To buttress its case, the Watson-Simpson team noted that the Barbados Light and Power Company indicated that it will require permission to adjust its depreciation rates as required when the Commission's depreciation decision is given in relation to its application for review of depreciation rates and approval of depreciation policy, which the Commission refers to in this decision as the depreciation application. The Watson-Simpson team argued that the Barbados Light and Power Company itself concede that the depreciation calculations contained in its depreciation application are incorrect and irrelevant based on the Commission's depreciation decision. The reasons for the orders sought seem to crystallize at paragraph 17 of the motion. In that paragraph, it is contended that the Commission, being aware of its decision of the 25th of February 2009 and an undertaking by the Barbados Light and Power Company, the Commission must have intended, when issuing the depreciation decision, that 1. That the applicant would not use, for the purpose of its application or at all, those elements of the depreciation policy or any depreciation rates that were denied by the Commission in its depreciation decision, and 2. That the applicant would not use, for the purpose of the application, the elements of the depreciation policy or the depreciation rates that were approved by the Commission in its depreciation decision. The Watson-Simpson team argued there was ample time subsequent to the depreciation decision for the Barbados Light and Power Company to amend the depreciation schedule in compliance with its undertaking. The Watson-Simpson team expanded on the grounds in its affidavit of Ms. Watson filed on the 9th of September 2022. The Commission has carefully considered the affidavit and the letters from the Watson-Simpson team dated the 8th of April 2022 and the 2nd of July 2022. The letter from Mr. Kenneth Ment dated the 4th of April 2022 and that from Mr. Ali Alfar dated the 14th of July 2022 and the other exhibits to that affidavit. We note the submission that the Watson-Simpson team had repeatedly sought by correspondence and oral submission in procedural and issues conferences to have the Commission direct the Barbados Light and Power Company to amend its application to provide the correct and relevant depreciation schedules, but failed to file a motion as required by the URPR until September 9, 2022. The Watson-Simpson team asked that the motion be urgently heard. The Watson-Simpson team set out reasons for treating the motion as urgent. The Commission decision on the Barbados Light and Power Company's application for a review of depreciation rates and approval of depreciation policy was given on the 25th of March 2022. The Commission will refer to its decision of the 25th of March 2022 as the depreciation decision. The Watson-Simpson team motion was filed on the 9th of September 2022 after the adjournment of the initial hearing, which was to begin on the 25th of August 2022. The motion preceded the start of these proceedings by approximately 11 days. It should be noted that the depreciation rates used in the application, which will be applied after a decision in this case, will not affect the accumulated depreciation or capital balances included in the overall revenue requirement. The Commission is of the view that the motion cannot be regarded as urgent given the time which has elapsed between the depreciation decision and the motion, approximately 5 months. The Watson-Simpson team had ample time to file such a motion. The Watson-Simpson team wrote the 2 letters referred to above requesting the Commission to direct the Barbados Light and Power Company to file revised or amended depreciation schedule states rate review application. The proper and appropriate way to move the Commission was to file a motion to precipitate a hearing. The Watson-Simpson team could have filed its motion earlier given the Commission's refusal to direct the Barbados Light and Power Company as requested by the Watson-Simpson team. Barbados Light and Power Company, in its depreciation application, applied to the Commission for approval of depreciation rates for transmission and distribution, general plant, and generation plant assets. The Commission, in its depreciation decision, approved the depreciation rates proposed by the Barbados Light and Power Company for transmission and distribution and general plant, on which the Barbados Light and Power Company's revenue requirements are calculated. The Commission did not approve the Barbados Light and Power Company proposed depreciation rates for generation plant, but left the depreciation rates for the generation plant to be proved and determined in these rate proceedings. Given the depreciation decision, there was no reason to request the Barbados Light and Power Company to amend its application to adjust the depreciation policy and rates to reflect the Commission's decisions and orders as issued on the 25th of February 2009. This Commission has already issued its decision on depreciation rates for transmission and distribution and general plant, and will decide the depreciation rate for generation plant assets in these proceedings. The fact that the approved depreciation rates will go into effect concurrently with the new tariffs speaks to the appropriateness of using the approved rates in the Barbados Light and Power Company's filings. The depreciation rates decided by the depreciation decision and in these proceedings will be applied to determine the Barbados Light and Power Company revenue requirements and calculate values that are dependent on depreciation rates and policies. Therefore, the Commission can discern no useful purpose in directing the Barbados Light and Power Company in the manner as suggested by the Watson-Simpson team. The Commission is satisfied that it is proper and appropriate to resolve the issue of the Barbados Light and Power Company's proposed depreciation rates for generation plant in these proceedings. The Commission agrees with the Watson-Simpson teams that depreciation doesn't have considerable impact on the other areas of the Barbados Light and Power Company's rate review application. For that reason, it is not unusual, as the Commission has done here, to review the company depreciation rates prior to the ruling on the overall rate case. This practice is more out of convenience than necessity. It is also not unusual for depreciation rates to be approved first and put into effect at the same time as the overall changes to the revenue requirement. It is also not peculiar for depreciation rates to be determined during a substantive rate hearing, along with the determination of the revenue requirement as occurs in other jurisdictions. Throughout any rate-making process, arguments for numerous adjustments to the revenue requirement will be heard by the Commission, and the revenue requirement requested by the company is rarely the same as that which is approved. After hearing arguments from the parties on each issue, the Commission will ask the Barbados Light and Power Company to recalculate the overall revenue requirement based on their decisions. This process does not preclude interveners in this case from reviewing or presenting their positions in the amount of depreciation expense in this case, and is typical in rate-making proceedings. An important concept in utility rate-making is that the revenue requirement reflects the expenses that were incurred in the test year, with adjustments for known changes that have occurred since that period. In this case, the rates for transmission and distribution and general plant going forward have been determined. Requiring the Barbados Light and Power Company to refile the application using stale depreciation rates from over 10 years ago when new rates have been ordered would be at odds with the goal of determining the correct level of rate recovery going forward. The Commission is satisfied that there is no reason at this stage to direct the Barbados Light and Power Company to amend its application to file amended depreciation schedules pursuant to the Commission decision dated the 25th of February 2009, or otherwise, or to adjust other calculated values that are dependent on the depreciation policy and rates. The Commission is also satisfied that the issue of depreciation rates for generation plant assets can be conveniently determined in these proceedings now before the Commission. The Commission now proposes to address the other orders sought in the Watson-Simpson team's motion. The Commission sees no usefulness in considering the declaration sought that the Commission has not concluded any proceedings for review, variation, or modification of the decision, and orders made in the 2009 Barbados Light and Power Company's application and the decision ordered remain unaltered. The Watson-Simpson team also seeks an order that the Commission discontinues the interim rate relief proceedings. At the time the Watson-Simpson motion was filed, the hearing of the application for interim rate relief had concluded, awaiting the Commission's decision. The application was made late in these proceedings. The Watson-Simpson team had submitted before now that the Commission had no power to grant interim rate relief. The current application does not advance that argument any further. The Commission has already given a decision on its power or jurisdiction to grant interim rate relief, and that issue has no practical relevance at this stage. This Commission's power or jurisdiction to grant interim rate relief would now have to be decided elsewhere. The Watson-Simpson team allege that the Commission acted in bad faith in not ordering the Barbados Light and Power Company to amend its application to present accurate and relevant depreciation calculations. It also alleged that the Commission acted in bad faith in not giving interveners notice of the order, and in so doing, it prevented the interveners from seeking a review or appeal of the orders as interested parties. Bad faith is a difficult ground of review to establish and should only be alleged where it can clearly be and expressly demonstrated. In this case, the Watson-Simpson team did not provide any evidence to support the allegation of bad faith. The Commission rejects the allegations of bad faith as alleged by the Watson-Simpson team. The Watson-Simpson team complained that the depreciation order was not served on them. Ms. Watson cited Section 34(2) of the Fair Trading Commission Act, which requires that a certified copy of that order must be served upon the service provider against whom it was made, and at the same time, notice thereof must be given to the other parties to the proceedings. The parties to the depreciation application proceedings were the Barbados Light and Power Company, BREER, and the Ministry of Energy and Business Development. The Watson-Simpson team was not a party to the depreciation application proceedings, and there was no obligation to serve them with a certified copy of the order. The Watson-Simpson team argued that paragraph 5 of the depreciation order is not in the depreciation decision and has the effect of amending the depreciation decision. The Barbados Light and Power Company made an application for depreciation rates to be approved in relation to transmission and distribution, general plant, and generation plant assets. The Commission made decisions regarding all the depreciation rates except in relation to generation plant. The Commission decided to defer the hearing and the determination of depreciation rates for generation plant to the substantive rate review application. Paragraph 5 of the depreciation order reflects accurately the decision of the Commission. In most cases in the Supreme Court in Barbados, orders are drawn by the parties, and once approved by the judge and the engrossed order signed by the registrar, it becomes binding. The Commission is unaware of any rule that the text of the order must follow verbatim the words of the decision. The Commission is satisfied that the depreciation order accurately records the decision of the Commission. The depreciation order of the Commission is the operative and binding document. In this case, the depreciation order reflects the outcome of the proceedings and the decision of the Commission. Contrary to the contentions of the Watson-Simpson team, the depreciation order is not void ab initio or unlawful. The Commission hopes that it did not misunderstand Ms. Watson, but understood her to be saying that 2 orders were issued following the depreciation decision. The Commission issued the depreciation decision on the 25th of March 2022 and the depreciation order on the 14th of April 2022. The Commission did not issue any other order in relation to the depreciation application proceedings. The Commission rejects the contention that the Chief Executive Officer decided that the issue of depreciation would be deferred until the rate hearing. As stated before, the depreciation decision decided the depreciation rates for transmission and distribution and general plant while deferring the determination of the depreciation rates for generation plant to these proceedings. The Commission understood the Chief Executive Officer as doing more than explaining or seeking to explain the effect of the Commission depreciation order. For the reasons given before, the Watson-Simpson team's motion dated September 9, 2022 is dismissed. The Watson-Simpson team made an oral motion for an order for the Barbados Light and Power Company to amend the rate review application to remove all references to the draft operational licenses, including but not limited to references contained in the application, the general memorandum, the memorandum on rate of return, and the memorandum on 5-year financial forecast. The Commission has already determined that the draft operational licenses are irrelevant and therefore have no prohibitive value in determining the rates. The Commission is alert to the fact that it should not take into account the draft operational licenses. To request the Barbados Light and Power Company at this stage of the hearing to remove all references to the draft operational licenses from the rate review application would necessitate an adjournment and would not be in the best use of time of the Commission and the parties. The Commission is satisfied that the concern of the Watson-Simpson team can be properly and appropriately dealt with otherwise, and that the draft operational licenses will not influence the decision of the Commission. The Watson-Simpson team's oral motion made this morning is dismissed. Thank you. We'll now continue with the cross-examination of Mr. Roger Blackman. Okay. Mr. Blackman, just remind you that you have affirmed earlier.
That's true.
So you're still on there. So I now invite the intervener team of Trista Watson and David Simpson to cross-examine this witness.
Thank you, Chair. Good afternoon to the panel and all assembled. Mr. Blackman, carrying on from your testimony on Friday, I wanted to revisit the issue of the self-insurance fund for a short while. It was my understanding, listening to your testimony, that due to the high catastrophe risk associated with operating in the Caribbean, that led to some challenges in you accessing insurance coverage to address the reference risk, and that it was determined to be more prudent that the Lighton Power should create its own insurance fund to address such risk. You also indicated to us that the fund was actually created in 1993 and was a trust associated with it under the legislation was created in 1998. On cross-examination by Commissioner Martinez, she raised some additional concerns surrounding the SIF, as I will refer to it, but I believe Commissioner Martinez appeared not 100% satisfied, neither did this team, in terms of having a full appreciation of the operation of the SIF and its reduction. Now, in a letter dated 25th of July, written to the Fair Trading Commission by your Manager of Regulatory Affairs, the company sought clarification and explanation from the Commission on the inclusion of the accountability and clawback mechanism as an issue in this rate hearing. On the 27th of July, the response from the Commission indicated the following. The issue of the accountability clawback mechanism listed at number 4 in the issues list refers to those requirements that were set out and approved in the 2010 rate review, but either were not implemented or are no longer being incurred by the applicant on behalf of the consumer. For clarity, an example of this would be that portion of the tariff that is to be paid into the self-insurance fund that is, however, no longer being put into the fund. So I want to have your responses to a few questions in that regard, using that primarily as the basis for such. I want to start by just having you reconfirm the quantum of the risk that you mentioned, because there was a figure that you mentioned in term referencing 1983, a figure of 730,000. So I just wanted to start by having you just reconfirm what that figure represented.
The 730,000 approximate figure that I referenced would have been the value of commercial insurance, third-party insurance, back at the time when the last rate decision in 1983 would have been made.
Okay, and how did that risk change between that date, 1983, and when the fund was actually created in 1993?
Between 1983 and 1993, the premiums, the cost of insurance would have increased quite significantly on the basis, I presume, of the level of risk perceived by the insurance market for the assets insured. And therefore, in 1993, the insurance, actually by 1993, not only had the insurance costs grown, but the availability of affordable commercial insurance, this is affordable third-party commercial insurance for T&D, became prohibitively expensive and unavailable, which would have prompted the establishment of the fund.
But I want to be very clear, Mr. Blackman, as to your assessment as to how the risk that the Light and Power faced in terms of adequately covering and acquiring coverage for its assets changed in that 10-year time period, which, from my understanding, precipitated your decision to create the fund.
The self-insurance fund.
Yeah.
Yeah, well, the risk would have been reflected in the inability of the company in 1993 to acquire insurance for, or T&D assets in particular. And what would have driven that, I believe I mentioned before, would have been experiences in the region in relation to Hurricane Andrew would have been a factor, and one that's come up and is mentioned in our submissions. So risks would have increased to the extent where we were unable to as a business, to purchase third-party insurance for T&D assets at a reasonable price, and therefore, not unlike other utilities in the region, the company at that time would have taken the decision to establish the self-insurance fund and later the trust.
And what are the specific types of risks that the fund is intended to cover?
The fund, at the time when it would have been established, was intended to cover risks associated with losses of T&D assets. So these are transmission and distribution assets of the business.
And that was the exclusive risk that was used
At that time, yes.
Are there any other categories of risk currently covered by the fund?
Yes, the fund would cover as well, I think I mentioned, or is intended to cover the risks, the deductible on third-party insurance, commercial insurance. Although, as a business, we haven't been applying that factor, so no claims have been made for third-party insurance for some time in the business. Can't remember the date we would have stopped that. But that is a provision that the fund is allowed to cover as well.
When did that additional type of risk, when was that added?
I am not certain. I would need to check and confirm subsequently.
So as it stands at today's date, these are the only two risks that the fund are intended to address?
Yes, risks associated with damage to our T&D equipment and coverage on our deductible, I believe, yes.
At its inception, what was the amount of capitalization of the fund, which I believe would have been in 1993?
In 1993, I think, first year, $2.5 million, if I'm not mistaken.
And the source of the funds for the capitalization would have been what?
Source of the funds would have been shareholder money set aside to establish the fund.
And the shareholder you refer to in this instance would be who?
At that time, the company, I believe, would have been publicly traded, so a combination of a number of shareholders at that time as the company would have been traded on the local exchange, I believe, in 1983. Again, I would have to confirm, but.
Okay, so the fund was started based on what you are indicating, using shareholder monies which would have been derived from the company being publicly traded at the time?
The fund would have been set aside by shareholders at that time in 1993 and established by the shareholder with money that would otherwise have been available to as a return to the shareholder or as a dividend.
So the shareholder funds set aside then, the source of the funds set aside by the shareholders, which were then invested in and to capitalize this fund, would have been what?
The source of the fund
Yes.
would have been shareholder equity, retained earnings.
In 1998, I believe you indicated on Friday that a trust was created under the governing legislation. Can you indicate the process can you indicate the basis which led to the decision being taken to create a trust? Was it simply, well, go ahead, let me not prompt you.
I am not certain of the process at that time.
Can you state the level of capitalization of the fund at the point in time when it was converted to a trust in 1998, or when the trust was created in 1998?
The level between 1993 and 1998, I couldn't give you a specific number. Again, that's something that I could check and provide to you.
Are any of the contributions made to the SIF, there is reference in the audited financial statements for the SIF of there being a minimum amount that is to be invested in the fund. There is reference in the audited one of the audited financial statements to the fund deed and a covenant that indicates the amount that are to be invested in the fund on an annual basis. Can you confirm if this is indeed correct?
A minimum amount to be invested in the fund? No, that is, to the best of my knowledge, not correct.
Was there an annual amount that was being contributed to the fund by the Barbados Light and Power up until 2013?
Yes, amounts were contributed to the fund up to 2013 and including 2013, but again, in response to your previous...
Now, what was that amount that was being contributed annually?
I believe we've submitted or provided that information in response to an interrogatory to Mr. Wendt. So subject to us referring to that specific interrogatory, it would have been in the order of $1.6 million. But that information is available in an interrogatory previously provided.
Are you in a position to read that interrogatory or otherwise confirm the amount that you refer to?
Yes.
Can you
Give
do
me a
so,
minute.
please?
Sure. I will have to use the laptop, and I believe I'm supposed to put it up on the screen. Not sure if the IT person in the back can pull the, there it is. Okay. So this would have been a May 3rd interrogatory during the interim relief process. And here you'll see the amount paid into the fund up to 2013. Not sure if you can see. Okay.
Sorry.
1.6 million in 2013.
And was that the fixed amount being contributed in accordance with the fund deed up until and including 2013?
It was an amount being contributed, but not in accordance. Like I say, there's no. I think the fund identifies a maximum, but no minimum, and so that was an amount that was being contributed to the fund at the time. 1.6 at the point when it ended in 2013.
And this 1.6, which you have corrected me, is a maximum and not a minimum?
No, the 1.6 isn't a maximum. I don't have the maximum figure at my fingertips now, but there's a prescribed maximum at which the fund should not exceed. That 1.6 is what was being contributed at that point in time in 2013.
Are the amounts that the company contributed to the fund the subject of any covenant or fund deed that commit the company to making this contribution on an annual basis?
Not that I'm aware of.
I want, based on your response, I just want to highlight in the most, up to the most recent audited financial statements, which would have been for the year ended December 31st, 2021, the auditors at note 1 have a statement which reads as follows. The fund is governed by a trust deed under which the Barbados Light and Power Company Limited covenants with the trustees to pay into the fund annually payments up to 20% of the total replacement costs which are being self-insured plus the self-insured portion of the company's commercial insurance program, or 5% of the total assets of the company where the replacement cost is not easily determined. So I'm just trying to establish that the amounts paid in, whether the minimum or the maximum, were being done in accordance with this covenant that the auditors reference in the notes to the financial statements.
That is correct. The amounts that were being contributed would have been in accordance with that statement you just read.
So as of 2014 until present, that contribution was ceased. Am I correct?
After 2013, no contributions have been made since then to the self-insurance fund. And just tracking back to the previous question, as I indicated, there's a prescribed maximum, which is what that statement you read refers to, but not a prescribed minimum.
So the basis for ceasing the payments from 2014 was what?
The payments were ceased then on the basis of assessments that were being done on the fund for its adequacy, and subsequently determined that the fund in fact was overcapitalized. The assessment, I believe I would have shared earlier, would have been conducted by the firm subsidiary of CGM Gallagher, who were the insurance risk assessors that would have evaluated the risk of damage in the market and the likely damage that we were expected or could expect to see given recent or history in the sector. And also assessments done internally by our asset management teams relating to, based on the experiences that we had had in the region with hurricanes as well.
I want to make sure that this team is clear on the auditor's reference to this trust deed and a covenant with the trustees. Is your interpretation of this covenant to make these payments that no contributions is not a contravention of the covenant? Is that your interpretation?
That is my interpretation, yes.
And this interpretation has been accepted by the Supervisor of Insurance and the Financial Services Commission where relevant?
We have made the submissions to the FSC on an annual basis as required under the fund. And so we have been reporting as required to the relevant agencies.
And your interpretation has been accepted by them?
there's been no concern raised with us in relation to our operation of the fund.
You reference the assessment done by a subsidiary of CGM Gallagher, which, by your testimony, found that the SIF was overcapitalized. Can you share your understanding of the basis on which it was deemed to be overcapitalized?
Yes, it would have been on the basis of the risk or evaluated risk in the market, applied, of course, to the T&D assets that we have and the value of T&D assets. And it would have been also, from our perspective, internally and our asset management teams in relation to the experience that we would have had in the region and within our businesses with hurricane events.
At the point where the fund was deemed to be overcapitalized, what was the value of the T&D assets? Are you aware?
I don't have that figure at my fingertips, but I can get that for you.
Because I would want to be able to make a link between the value of the T&D assets, the evaluated risks that you refer to, and then also to understand the findings of your internal asset management team, who you seem to be suggesting made an assessment of the risk space in terms of hurricanes and other catastrophes. I assume you mean historically?
That's right.
Which then supported
The work done
the
by,
position that it was overcapitalized.
yeah, and the position of the risk assessor from the insurance company as well. So it would have been in conjunction with the work that they would have done on our behalf.
So did the risk of catastrophe fall, or the risk reduction is being based on not having had to make any payments out of the fund directly for catastrophe? Because my understanding of catastrophes and the coverage is that they could occur at any time. So I want to be clear as to, especially in the Caribbean region where we have a predominance of storm and hurricane activity, as we see even today as we sit here. So I want to make sure that we are clear as to the assessment of this risk. Is there a report that is available outlining the findings and the work done to determine that the fund was indeed overcapitalized?
Yes, there is work done in the report on that matter.
Chair, would it be possible for us to request a copy of that report be provided to the proceeding?
Yes.
Thank you. In 2015 or 2016, on the basis of that report, the audited financial statements indicate that just under $100 million were transferred to a related party. Can you indicate who that related party is?
That would be the Barbados Light and Power Company.
What makes the Barbados Light and Power Company a related party of the fund?
Well, Barbados Light and Power Company would have been the company that established the fund in the first place and the need for the trust. So in my mind, that would have made it a related party and is the beneficiary of the fund at the end of the day in relation to any damage or claims that may be made against the fund for the T&D assets.
So you are testifying that the Barbados Light and Power Company is the beneficiary of the fund for the purpose of settling any damage to T&D assets?
Yes, the Barbados Light and Power is the one that will make a claim on the fund for any damage to the T&D assets. Whether or not that makes it the related party, I am not 100% certain, but that's the relationship that Barbados Light and Power Company would have with the fund and the trust.
Can you indicate what the transfer to the beneficiary was for at this time? In your testimony on Friday, you indicated a return to the shareholder. You've listed Light and Power as the beneficiary, so the funds were transferred from the SIF to the beneficiary, Barbados Light and Power Company, but in your testimony on Friday, you indicated that the funds were returned to the shareholder.
Yeah, well,
Can you
when
clarify if the shareholder and the beneficiary are one and the same entities?
No, when I reference Barbados Light and Power as the beneficiary, it is in relation to making claims on the fund. The fund, when it was right-sized, because as I mentioned earlier, it was overcapitalized, that transaction would have been one in which the funds were returned to the shareholder through the Barbados Light and Power. Who makes the contributions to the fund?
And the shareholder of the Barbados Light and Power Company at the time of this withdrawal was who?
It would have been Emira Caribbean Holdings.
So it is your testimony that 100 million was transferred to the Barbados Light and Power Company and then paid out to its shareholder, Emira Caribbean Holdings.
Not entirely correct, because there would have been taxes payable on that fund to the order of maybe $15 million or so. So net of the tax, what would have gone to the shareholder would have been in the order of $85 million. And $50 million would have been paid, again, rough numbers there, $50 million paid in taxes.
So I take it the 15 million paid would have been in accordance with the legislation, which indicates that if funds are withdrawn from the SIF for any other reason than settling claims, that such a withdrawal will be subject to tax.
That's correct.
Okay, so out of the 100 million, 15 million was paid in taxes to the Barbados government, and 85 million was paid over to the shareholder.
Yeah, rough numbers.
Rough
Get
numbers.
exact.
Yeah, probably rounding for accuracy, because the exact figure was 99 million and some, but
That's right, 99.
rounding the figures for the purpose of your testimony.
Okay.
Is it safe to say that the 85 million paid to the shareholder was a dividend payment?
It was recorded in the financials as a dividend payment in the financial statements.
Your current application before the commission, Mr. Blackman, is one of the conditions of your request for a review, the ongoing viability and strain cash flow of the Barbados Light and Power Company Limited?
I believe we identified where are you reading that from, may I ask?
I'm asking you, sir.
Okay, but we would have provided the reasons in the application. If you want to give me a minute to pull it up, I can.
So can you share the reasons then?
Yes, I can. Give me one sec. So I'm pulling up the general memorandum in which we shared the reasons for the application. And just one sec. In paragraph 10, we identify them as the increased cost of operation. You should be seeing it on the screen. Oh no, for some reason the screen is gone, but increased cost of operation, including depreciation, lower sales. We certainly didn't see the sales that we had anticipated back in 2010 when the last decision was given. Clean energy transition investments that were made in the last 12 years and that we anticipate we will continue to need to make, as well as meeting government's mandates for the electricity sector.
So the viability of the company its cash flow, or as was in one of the submissions and sworn affidavits from one of the officers of your company, the commitments to cash flows over the last 3 months?
That would be important as well, yeah. I believe what you may be referring to is submissions on the interim application. Not certain where you're reading, what you're reading from.
So in the context of the current application, is there any consideration of the company's viability based on its future plans and its current cash flow position? Has that impacted the company's application in any way?
Sorry, could you repeat the question?
In the context of this current application before the Commission, has the company's cash flow or future viability based on cash flow been instrumental in your application for the rate review at this time?
Certainly the company's viability is a factor. We need to be, as a company, be able to attract capital to make the required investments on an ongoing basis that are required to maintain a safe and reliable operation. So I would say yes, viability is important. And of course, cash flow is important for the business as well. You need adequate cash flow to meet your commitments. But again, I would highlight that the primary drivers are those that I identified earlier, which would be the increased cost of operation, lower sales, the clean energy transition investments that we're making and meeting government mandates as we've identified before. And yes, the overall viability of the business to be able to deliver a service that is safe and reliable.
Is it reasonable for me to deduct, therefore, that based on your testimony, increased cost of operation for the Light and Power Company, coupled with, as you have testified, reduced or flat sales over the recent history, together contribute to a cash flow issue for the company?
Objection, Mr. Commissioner, through you, sir, is calling for speculation in terms of the witness. The question asked, I believe, should be reframed so as the witness could be clear. In other words, sir, the question as poised is asked whether it is reasonable for him to come to a conclusion as opposed to a specific assertion within the factual matrix before the Commission. So we will be objecting to that form of speculative question, sir.
Counsel, could you rephrase the question, please? So, yes, please.
The objection, sir, is that the witness is being asked a speculative question as to whether he agrees with the deduction. The witness has given an answer based on the factual matrix which he has presented and has provided the documentary support for the answer given. The intervener is now asking the witness to provide an agreement to a deduction which he has come forth, which at best is a speculative determination of a factor not included in the factual matrix which the witness has put before the tribunal, sir. In these circumstances, we believe that the question is unfair and should be reworded so the intervener can seek to get the point across without having the witness speculate.
Mr. Simpson, would you care to rephrase the question?
Mr. Chair, if I may intervene, the very nature of these proceedings require speculation, and the witness is the managing director of the company with general oversight on strategy, which is in itself speculative. The applicant has made certain assertions regarding cash flow, regarding its expectations on those limitations on the viability of the company. It is appropriate to put a question to the managing director of the company that causes him to speculate on the impact of cash flow issues on the company. That is their very evidence in the application.
That is, sorry. Mr. Commissioner, that is certainly not the case. When asked as to whether cash flow was a factor, the witness took the commission and the intervener to the relevant exhibit which set out the factors which were the bases. Cash flow was not there. If they wish to lay a foundation, they have to ask the question in the appropriate manner, sir.
Chair, I thought my question was quite clear. So let me see if I can rephrase the question this way. Mr. Blackman, does the Barbados Light and Power Company Limited, up to the date of its current application for a rate review, have a cash flow problem?
At present, we are able to meet the commitments that we have, but it is not without significant challenge and effort on the part of the finance team. I think when he is on the stand, my Director of Finance, he will be able to give you a far greater context and detail around what those challenges are and how we've been seeking to manage them. But again, in response to your question in relation to the factors driving the need for the rate, we also indicated in paragraph 59, in addition to paragraph 10 of the general memorandum, the primary factors that are driving the need for a rate review at this time. And again, those include increasing production, distribution, and administrative costs, the significant network investment costs to support reliability levels, as well as I mentioned before, the transition to renewables, and a requirement for new smart technologies, which I spoke quite a bit about on Friday. On the matter of viability, of course, the viability of the company is important and necessary and a factor as well.
But I want, Mr. Blackman, I hear your testimony, but I want you with a yes or no answer, if possible, to respond to this question. Does the Barbados Light and Power Company Limited have a cash flow problem?
Excuse me, Chair. The witness has answered the question quite clearly already. This is a repeat of the same question. The fact that it is phrased in a manner that Intervenor Simpson is not wishing to receive is not a basis to repeat the same question.
But we would try to attempt balance on both sides, and we do note that it is in the application you would have submitted information pertaining to your forecasting, to your 5-year capital expansion plan, all of this. And I think that all the interveners seeking to get an answer in relation to whether or not the company at this present time is having a cash flow problem.
Quite fair, Chair, and I have no issues with the query. That's why when the witness answered it, we didn't make any issue. We are now repeating the same question. If we continue like this, we'll be here all day.
Mr. Blackman, could you just answer the question?
Repeat the question for me.
The question is, does the Barbados Light and Power Company have a cash flow problem, yes or no?
It depends on how you define.
Again, you cannot indicate to the witness that he has to answer it yes or no. You get to ask a question. You're now dictating the answer.
Chairman, would you be so kind as to direct the witness to actually answer the question?
Yeah, Mr. Blackman, could you answer the question?
Yeah, if The challenge that the company has in relation to cash flow is that if we aren't granted adequate rates, we won't be able to meet our commitments. So cash flow will be a problem, yes, and we won't be able to meet our commitments. Of course, we do everything that we can to manage that, like every other business, on a month-by-month basis by making decisions about how and who you pay. So we are able to manage on a month-by-month basis, but it is not sustainable the way we are operating now without, without a form of relief. So we've recently gotten a decision from the Fair Trading Commission for a partial interim relief, which eases some of the pressure, but certainly doesn't address the gaps that we've identified in our application. And what is necessary for the sustainability of the business over the long term.
Thank you, Mr. Blackman. Was it an act of sustainability in 2015 when the overcapitalization from the SIF transfer to the Barbados Light and Power was paid out as a dividend of $85 million to Emira Caribbean, its shareholder?
Question is whether it was an act of sustainability.
Yes, sir.
It was an act of returning what which was contributed by the shareholder over that period of time that the fund was established. I'm not sure I understand the question in relation to an act of sustainability. I would have.
If the viability of the company needs to be protected, to enable it to be able to continue providing a safe supply and an improved supply of electricity to the consumers of this country, would the payment of that withdrawal over to the shareholder be prudent in your quest to be sustainable, viable, and be able to provide an ongoing supply of safe and consistent electricity supply?
Yes, it was prudent, as I had indicated before, because that was the source of the fund, and that occurred 7 years ago, and we're here 7 years later making an application. Right, so I'm not.
The source of the fund was the shareholder?
Shareholder, the source of the money put into the fund over the period. Maybe let me step back just a little bit again in relation to that matter, because I know there were some questions on it on Friday. The decisions that are relevant to the whole discussion here around the SIF would be the 1983 rate decision, and then the immediate past one in 2010. Between those two rate decisions, 1983 and 2010, the value of the amount of money that would have been included in rates for all insurance costs of the business was in the order of $20 million from 1983 to 2009. Over that same period, the actual insurance cost of the business was in the order of $71 million. So just to recap, between 83 and 2009, included in rates for insurance based on 1983 decision would be in the order of 20 million over that period. However, 71 million was paid over that period, actual insurance costs. On top of which, a further 99 million was set aside in a self-insurance fund over the same period because, as I mentioned earlier, T&D insurance wasn't commercially available or reasonably available at a reasonable price. So we have 20 million in rates between 83 and 2009. 71 actually paid in third-party insurance and an additional 98 million set aside by the shareholder above and beyond that in the self-insurance fund before accounting for investment returns on that fund, because the fund, as you mentioned earlier, would be in a trust which is invested. In 2010, in that rate decision, insurance costs and contributions to the fund were included in the last rate decision in 2010. And contributions of 12 million, 12.5 million would have been made subsequently, contributing to the overall value of the fund by the time it was right-sized due to overcapitalization. So when the roughly 98 million, 99 million was withdrawn, we say 100 million, easy number to remember, that essentially represents what had been contributed before investment income up until 2010, the last rate decision. In fact, the investment income would have been left behind in the fund together with the contributions from customer from the last rate decision, which represents essentially what is in the fund today. So, sort to recap in a way that maybe rephrases it slightly different to how I communicated it. It's the same information, but looking at it over the full period to give maybe another angle or context on the withdrawal.
So I just want to make sure I'm understanding what you are saying. Are you indicating that the funds currently left in the fund after the withdrawal are made up of the investment income earned by the fund
Roughly, yes.
plus the portions of monies from collections from consumers? Is that what you are saying?
As well as any investment income on that contribution as well over the period to 2013.
And that what was withdrawn was the investment by the shareholder which was repaid to them?
And what was withdrawn was the shareholder money that was set aside, and it is equivalent to the money withdrawn, roughly.
So I need a little more clarity, Mr. Blackman, because in your earlier testimony you indicated that when the fund was created in 1993, that the company was publicly traded and the funds would have been sourced from input from multiple shareholders. Is that correct? Or did I misunderstand your testimony?
There would have been multiple shareholders of the business at that time, as opposed to a single shareholder, but the fund was set aside by the shareholders in the business at that time, yes.
Okay, so the fact that the return of the withdrawal was to a single shareholder, can you just explain that for the benefit of this team and others listening?
Well, the return would have been to the shareholders or shareholder in the business. What happened during that period is that the ownership of the shares changed hands, but the principle of returning it to the shareholder remains the same. The shareholders did change, as can happen and has happened in this instance.
Okay. Was any consideration given to the operational needs and the capacity of the company prior to paying out this amount as a refund or return to the shareholder? In other words, I'm asking, was any consideration given to making a smaller return or a partial return so that the Barbados Light and Power Company could have easier met any obligations for operations, upgrades, anything during that period of time?
I believe those considerations would have been made at that time, in fact, that was, 7 years ago? And so we're here 7 years later, so I mean, that speaks, I think, for itself as well. The business was able to manage over the last 7 years since that transaction, and as we always do, we manage costs and expenses in the business to avoid having to come back and request rates until it's really an absolute necessity as it is at this point in time.
When did Emera Caribbean become a shareholder of the Barbados Light and Power Company?
Emera Caribbean would have been subject to correction, and that information may be in our submission. I want to think it was around 2009 would have been the first time they would have become a shareholder, but let me confirm, I can get that confirmed for you.
What is the current, if you are qualified to answer this question, what is the current dividend policy of the Barbados Light and Power Company?
So the Barbados Light and Power Company does not have a formal dividend policy. I think we would have addressed this in several past interrogatories, and rather than point you to those, maybe just to give an overview. While we don't have a formal dividend policy, there are some criteria that determine, that govern how dividends and decisions around dividends are made. And those are threefold. One is solvency of the business and ability to pay. Another is the prevailing economic conditions at the time. And the third would be seeking to manage our capital structure as a business.
Would one of the criteria include, because I hear the ones you've listed out, but would one of the criteria, you mentioned solvency,
Yeah.
would one of the criteria be the future capability of the company to conduct its affairs and its operations?
I wouldn't phrase it that way. What I would say is, as I mentioned previously, is that you look at the prevailing economic conditions. For example, in 2020, when COVID struck, and given the significant uncertainty that the business and the entire island and the world, and for that matter, would have faced, while the returns that are approved would have dictated a certain level of dividend and return to the shareholder, none was paid in that year. And so the level of uncertainty that existed at that time as a result of COVID and the circumstances, the prevailing economic circumstances at that point in time, would have influenced the decision to not pay a dividend, even though not paying a dividend at that time resulted in the business moving further away from the approved capital structure that would have approved at the last rate case of 65-35. 65% equity. So as I said, the third factor is, of course, managing the capital structure of the business, and the dividends are the lever that you use to achieve that.
And the criteria that you listed in the absence of a formal dividend policy, to use your words, the responsibility of the management or oversight for those criteria falls to whom?
To the board of directors.
And
Supported, of course, by the management of the company, but the decisions around dividends, as you probably appreciate, would be the board of directors.
you referenced no dividend in 2020 with reasons, which I understand. So I have two more questions, I believe. The criteria that you listed out, solvency of the company, just to clarify, are you referring to the level of dividend paid out vis-a-vis the amount of net income in the particular year? Or does it go further than that?
I'd probably defer that question to my colleague in finance, but it is in relation to our ability at that point in time to be able to pay that dividend in consideration of the capital structure of the business and what we're trying to achieve, the return that is approved, and our ability to pay, as I mentioned earlier.
So in 2020, based on responses to interrogatories, the net income stated was 28.72 million, and no dividend was paid for the reasons you gave. For the financial year 2021, the net income was 24.58 million, and a dividend of 25 million was paid. So I just want to make sure I understand the criteria of solvency and ability to pay and so on that you listed as criteria that the board considers in declaring and paying a dividend.
What is the question?
So how were the criteria applied in 2021? I understand what you are indicating for 2020 and none was paid.
Right.
But how were the criteria applied in 2021 when the net income was $3 to $4 million less, but a dividend of 25 million was paid?
So we would have, I mentioned three criteria: solvency, that was satisfied; economic conditions, we would have come out of the worst part of COVID in 2020 and have some signs of recovery from 2021. But the third one in relation to capital structures would be the overriding factor there. I mean, we have $550 million in equity in the business. And at 12.5%, that would be a return of $70 million. So in the context of trying to, and a capital structure that is well away from the 65% that's approved by the regulator. So in the context of all of that, and 70 million being a reasonable return in the circumstances, 25 was paid instead of 70, in an effort to balance all of those factors. That didn't get us anywhere near where we need to be, and it actually still a fairly slow movement towards the appropriate capital structure, the one that's approved for the business. But we can't ignore the fact that we need to correct that as well. And so it was striking an appropriate balance between the economic circumstances. Things were not quite as bad as they were in 2020. We did have net income to support payment of that dividend, and our capital structure was nowhere near where it needs to be. In fact, it still isn't at the appropriate point. And so we didn't pay 70 million, which is the return on 550 million, but we paid 25, which we thought was very reasonable in the circumstances.
The point about the capital structure, and I just want to make sure I'm not getting confused. You're suggesting that the payment of the dividend, even though you're indicating it was less than should have been paid, if I follow you correctly, was to ensure that you maintain the required capital structure ratio?
Not to maintain it, but to manage it, because if you are being regulated on a 65% equity basis, and for much of that period, as you probably see in the interrogatories you've provided, you're 80% or north of that, then that in the long term isn't something good for customers, because running higher levels of equity will increase our, up to a certain point, will increase our cost of capital, which is why the rates were determined on the basis of 65-35. So we have that responsibility to manage to that capital structure that the rates have been determined on. And that's what we sought to do over that period. And that is, in fact, one of the criteria that is considered when we make determinations around payments of dividends. To not pay a dividend would allow the capital structure to get away from us in terms of increasing the level of equity in the business.
No. So I need you to explain that, Mr. Blackman. I think that is the source of my confusion, because I am not following your explanation that not paying the dividend would affect the capital structure of the entity and affect that ratio of 65-35 or whatever the target was. So can you please elaborate on how the payment or non-payment of the dividend, in your opinion, affects the capital structure that you're required to maintain?
So the dividend is essentially, my understanding, a return to the shareholder. And in paying dividends to the shareholder and paying return, making that return to the shareholder allows us to keep the capital structure, manage the capital structure to a particular level. So the levers we have available to us would be paying dividends, as well as borrowing money to invest in investments that we have as a business. And so it's on that basis that we use dividends as a means of managing the structure.
Right, so you can understand acquisition of new debt changing the capital structure, or issuing of new shares changing the capital structure. But the payment of dividends is a return on that capital structure, the equity component for sure, but it does not change the capital structure.
Objection, Mr. Chairman. Now we're entering into an argumentative line. The witness has given a response to the question as posed.
Counsel, I didn't think that was the exact question that the intervener was asking, because the intervener is seeking to look at the whole question of what is capital structure, and therefore he was asking the witness if he could explain to some extent the whole question of why the capital, in focusing on reducing your capital structure, why they focus on the dividend payment and not the other components. That is my understanding of the question.
Sir, thank you. Our notes reflect that the witness was asked the question in relation to the procedure behind the dividend, the policy. The witness gave the response in relation to the debt to equity ratio. We now have an inference of a fact being put forward as a question that is posed, and the witness has already said, one, I've given my answer in relation to the debt to equity and the payout, and two, matters of this detailed nature might be better directed to my financial controller. We are simply submitted, sir, that it is argumentative for this principle, which is being restated, question having been answered, to be put to this witness after he has given a response to the same substantive principle question that was asked, sir.
But counsel, the witness did indicate that the three grounds in terms of where the dividend policy, I'm just going back to where the dividend policy was, is one was insolvency, two, the prevailing economic conditions, and three was seeking to manage the capital structure. All the other questions were in relation to that issue relating to the adjustment to the capital structure, because the witness did indicate that that was the grounds under which this payment was made. So
Exactly, Mr. Chairman. So the witness having indicated that, it is now argumentative to put forward your interpretation and bases for the said payment. Mr. Chairman, you've just hit the nail on the head. So if a witness gives an answer as to why something was done, it is either speculative or argumentative to put forward your understanding or your bases why it was to be done, and it must be considered that the witness says, for deep financial matters, my FC is coming. So that is the basis for our objection, sir.
okay, and I could understand that, but we are basically, you and I now becoming argumentative as all I think the intervener was asking was for clarification.
I am guided if the intervener can rephrase his question to ask what he's seeking to be clarified, sir. I have no issue with that, Mr. Chairman.
Okay.
Thank you, Chair. So, Mr. Blackman, you testified not long ago that the dividend paid in 2021, even though less than what it should have been, was paid to enable the company to maintain its capital structure. Am I correct?
No, I don't believe I said that. I said the dividends, one of the levers we used in determining the dividends to be paid is the capital structure of the business, in addition to solvency, ability to pay, and the economic circumstances. When that dividend was paid, yes, the capital structure would have been a factor that was taken into consideration.
What?
And the appropriate capital structure for the business, 65-35.
I will take your invitation to cross-examine my professional colleague, your Director of Finance, when his turn comes. But I will end by asking, in relation to capital structure and dividends, were there any capital calls or issuing of new shares by Emera during the last, by BLMP during the last 5 years or so?
No, not that I'm aware of.
The
No.
last 10 years?
10 years would, no.
So any adjustment you have achieved in terms of your capital structure has been primarily through the acquisition of debt?
That's right.
Okay.
Would be the acquisition of debt, and for making investments in the business, as well as managing how we manage dividends and dividend payments in the organization.
All right, my co-intervener has some questions for you, Mr. Blackman.
Mr. Blackman, when did you become a
Excuse me,
trustee?
Chair, just for clarification on your procedure, did we indicate, or did the chair indicate the nature of a representative to do cross-examination, or will we have a situation of multiple persons doing cross-examination?
We did not indicate, but it is the Watson-Simpson's team that would have been the interveners in this matter. So we did not indicate that only one person could ask the question.
Mr. Chair, I would hope that if that's the suggestion, then there would only be one counsel asking questions on that side, or making any submissions. Mr. Blackman, when did you become a trustee of the self-insurance fund?
Became a trustee sometime in 2016 or early 2017, somewhere in that period.
Mr. Blackman, who appoints the trustees of the self-insurance fund?
The appointment of the trustees, I am not, hold one sec. So the appointment of the trustees, I'm not certain, I would need to check. I know the process that I would have gone through, but I can't remember exactly who would have had the responsibility for appointing the trustees. I believe it may be the Barbados Light and Power Company.
By the Barbados Light and Power Company, do you mean the board of directors of the Barbados Light and Power Company?
Yes, I believe so, but I would need to confirm that.
Who were the trustees of the fund when the funds were paid out in 2015?
In 2015,
That's the $100 million, $99 million.
the trustees in 2015, I can't remember the name of both. There were two trustees at that time. One would have been Richard Edgell, and the second would have been, I believe, Andrew Gittins. But again, if you would allow me, I could confirm that for you.
Please do. Who were the board members of the Barbados Light and Power Company when the decision was made to no longer capitalize the fund?
I would have to get that information and pass that to you. Happy to do so.
Please do. I hope a record is being made of these promises. who were the board members when of Barbados Light and Power Company when the funds were paid to Emera?
Again, I can get that information and provide it to you. I suspect it might have been the same board members from the previous question, but I'll need to get that information and confirm that for you.
Mr. Blackman, are you familiar with the terms of the trust deed?
Yes, somewhat. I couldn't rattle it off the top of my head,
Sure.
but I have looked at it in the past.
What are the assets of the fund?
The assets of the fund at the end of the test year, I think we have that indicated in the application, somewhere in the order of 32 million US, 64 million Barbados dollars.
Mr. Blackman, as a trustee and as the managing director of the company, are you aware of the statutory requirement that the assets, that $30 million, thereabouts, 32, as a matter of law, are not to be assigned by the company?
And by assigned, you mean what?
Given, promised, anybody
Mr.
else
Chairman,
transferred?
the objection is, while the question itself as to the knowledge of a managing director is fine, I think if my friend would rephrase as a matter of law, the witness might be in a position to answer. If the question is posed as a matter of law, the witness is not an attorney at law and obviously cannot be asked that question, sir.
The witness is a trustee of the fund.
Sorry,
The
Mr.
witness has also said that he's responsible for compliance, he's the managing director, he's a member of the board. It is an appropriate question because he is obligated to know the rules applicable to that fund. That fund is established under a statutory instrument. That's the law to which I'm referring.
Mr. Chairman, if it can be rephrased, I have no issue, but you cannot ask a witness who is not an attorney at law a question as a matter of law. That is basic rules of evidence, sir, which applies both to tribunals and the court, sir.
Chair, I have not asked a question as a matter of law. I have asked a question to a trustee of a fund, a statutory fund, to make a comment regarding the requirements under that legislation, but that's his obligation.
Mr. Chairman,
That
that is
is
not
his
the case.
fiduciary
My friend
duty, Mr. Chair.
specifically said as a matter of law, and I said if that portion is removed, we have no issue, sir. The concern is this, sir. When you ask a witness a question, the witness has to answer truthfully, etc., etc. You ask a witness who is not an attorney at law to opine on a matter of law, that is clearly unacceptable, sir. And that was the words. We have the benefit of these transcripts, sir, which were asked.
Mr. Chair, I'm happy for the transcript to be read back.
Your contention is only that as a matter of law, but
That is correct.
But the rest of the question
No
is
issue,
fine.
sir, but the issue with the reference to a matter of law should not be allowed in this tribunal, sir.
Because I think all the intervener was seeking is the witness understanding under the necessary legislation of his duties as a trustee.
And if my friend will be so guided by you, Mr. Chairman, I believe the question could be asked properly.
Mr. Chairman, I'm going to refrain from making any commentary on counsel seeking to reframe my question. My question is very straightforward. Mr. Blackman is a trustee. Mr. Blackman must be aware of the governing legislation. I'm asking Mr. Blackman if he's aware under that legislation that those funds are not to be assigned.
Not to be assigned by who?
By the trustees of the fund. You're free to say no, you're not aware.
So the question, just rephrase the question. The question is, Am I aware as a trustee of the fund that the funds are not to be assigned
Not to be assigned by the company.
by the Barbados Line of Power?
Yes.
Yes, I am aware of that.
Mr. Blackman, are you aware of the existence of any shareholder resolution creating the fund?
No, I'm not aware of a shareholder resolution creating a fund, although I wouldn't be surprised if there was one.
You expect that if
Yes.
the shareholders determine that they're going to create a self-insurance fund, that there would be such a resolution within the company's documents.
Quite possibly, I would expect there would be one, yes.
Mr. Chairman, I would ask that the company produce such a resolution. The evidence is that the fund was created by the shareholders of the company, and we would want to see the relevant resolution creating the fund and any rules relating to the creation of the fund. So direct the company.
Chair, I do not believe that the issue of a resolution of the Board of Directors creating the fund is relevant to the issue beforehand. If there was a request for the trust deed that
That's coming,
operates,
counsel.
or if there was a request relative to the legislation, but I do not know it's appropriate to be going into the resolution of the Board of Directors. That is not relevant for any assessment that this tribunal has to make.
Mr. Chairman, I didn't ask for a resolution of the Board of Directors, actually. I asked for the resolution of shareholders.
That only makes it worse.
Creating the fund. It doesn't. It's relevant because it's a statutory fund. It's a fund into which ratepayers' money goes, and it is appropriate that the parties to this proceeding, given how the fund has been managed or not managed, it is appropriate for us to look at the intricacies of the establishment and the management of the fund.
Chair, the correct indication there is a statutory guided matter. Statute will indicate what is necessary or not necessary. The trust deed will indicate what's necessary or what's not necessary. Resolution of the shareholders does not. As I said, it is not relevant for any consideration that has to be made by this commission.
Okay. So we note that the resolution of the shareholders is not relevant at this time.
Mr. Chairman.
Thank you, Chair.
Mr. Blackman, can you produce for the parties the covenant reference in the notes to the audited financial statements, let's say up to 2021, regarding the self-insurance fund? That's a request, Mr. Chairman. We'd also like the company to produce the trust deed governing this self-insurance fund. I guess I can go through with my list of the things that we'd want, given the evidence of Mr. Blackman. Can Mr. Blackman also produce the approval sought from the following entities regarding the payout of the 99 or $85 million to Emera? Any approvals from the Financial Services Commission and any related correspondence from the company? Approvals from the Fair Trading Commission? If the answer is it's not relevant, then simply give us the answer. The approval of the central bank for the payment of any foreign exchange.
Yes, we can produce those documents.
And we'd want the application for the payout of the foreign exchange. Yes?
We
The
can produce,
exchange control permission application.
certainly.
Thank you. Yeah. For clarity, Mr. Chairman, we'd also want to have the assessment document produced by the subsidiary of CGM Gallagher and the report produced by the internal asset management team. And an indication as to when we can receive those documents.
Mr. Blackmon, would you be able to produce those documents by Thursday of this week?
Yes, yes, Mr. Chair.
Okay.
Mr. Blackman, let's continue. As a trustee of the fund, you've made reference to the risk, the assets being covered being the transmission and distribution assets. Are those the only assets covered by the fund?
Sir, Chair, the question has already been asked by intervener Simpson and answered. I don't know that we're going to have the same questions asked by both parties. I take your ruling as to the right, but there's no need to repeat the same questions.
Mr. Chairman, my co-intervener asked what assets are covered. I'm asking if those are the only assets that are covered. There is a difference.
Sir, the witness answered and indicated two things were covered: T&D and any excess in relation to commercial claims. That's within the transcript, that's within the evidence. It has already been answered.
Mr. Blackman, are you aware that the company has a statutory obligation to cover generation plant, equipment, buildings, and other contents of buildings under the self-insurance fund?
I'm aware that, as I mentioned earlier, that the deductible on our third party for those particular assets can be covered by the self-insurance fund.
Are you aware that the company has a statutory obligation to cover generation plant, not the deductible, the generation plant, equipment, buildings, and other contents of the building under the self-insurance fund?
I am not aware of that.
Does the company cover generation plant, equipment, buildings, and other contents of the buildings under the self-insurance fund?
As far as I am aware, the company covers, the self-insurance fund covers the deductible on the commercial insurance for those assets that you described.
That is a no to the question that I've asked.
But not really a no.
Says I asked specifically about. I
Mr.
didn't
Chairman,
say-
the witness has given
Mr.
a
Chairman,
response, so the
could you
statement,
kindly ask
I'm
counsel
objecting,
not to
counsel,
interrupt?
I'm objecting,
I
counsel.
did not interrupt counsel when counsel
Counsel,
was
I am,
questioning.
Mr. Chairman,
Please,
sir, I am
thank you.
allowed to state an objection when counsel, the witness has given an answer. Counsel then overtalks the witness. The witness says, "This is my answer," and I'm not allowed to object, sir?
We're not
Chair,
saying
I
that you're
did
not,
not
we're
overtalk
not saying
the
that you
witness.
are not allowed to object, but I would prefer that you would state your objection after the intervener has posed the question.
Sir, it was stated after the witness said, in response to the question, he gave a phrase. Counsel then indicated that is a no. The witness then said another phrase. Counsel then repeated the question. The witness is not being allowed to ask this question or to give his answer. If you do not like a question that was given, Mr. Chairman, the procedure is that the witness be allowed to give his response. The fact that you don't agree with it, you take another step, but you don't continue with another question and badger the witness who is trying to respond to your first question because he did not give the response that you wanted in a yes or no fashion. If the witness is asked a question, Mr. Chairman, we all hear about fairness. Please, may the witness be allowed to respond. That is all we're saying on this side, sir.
Yes, so noted.
Thank you, Mr. Chairman.
So continue.
Mr. Blackman, is generation plant, let me make it clear. I'm not speaking about the deductible. I'm speaking about the assets. Are you clear on the difference?
Yes, I am.
Good. Is generation plant covered under the self-insurance fund?
As far as I am aware, the self-insurance fund, as I indicated earlier, only covers the deductible on the generation plant and
Mr.
T&D assets.
Mr. Blackman,
Miss-
could you?
Ms.
Yes,
Watson, just let him finish.
But that's the,
So I'm going to ask the question again because I think it's a straight answer. It's really simple. The answer is yes, it's covered, or no, it's not. So I think that can be done without reference to any other coverage that we're already clear on. I know council wants to jump in because council wants to direct my cross-examination, but I will not allow that to happen. Mr. Chairman, could you kindly ask Mr. Blackman to answer the question? It's a very straightforward question. Is generation plant covered under the self-insurance fund? That's simply yes or no.
Chair, council cannot direct the answer she wants. That's fundamental. She doesn't like the answer that was given, I understand that. But it is clear what the answer is. I know it, I've always referenced it when it was answered to Intervenor Simpson. You cannot tell the witness to tell you yes or no.
Mr. Blackman, could you answer the question?
so the answer, as far as I'm aware, the self-insurance fund covers the transmission and distribution assets, as well as assets within a certain proximity, and I can't remember the specific distance of a substation, and the deductible on generation plant assets.
Mr. Chairman, I really don't want to go over the same question over and over. A generation plant is explicitly described in the assets of the company. I think Mr. Blackman, having worked with the company for a considerable period, he's an engineer, he would know what generation plant is. And I would simply like him to say whether the generation plant owned by the company is covered under the self-insurance fund.
Chair, I repeat,
Sir, I think
it
that
has
should be
been
answered.
answered.
I think that
And
can
I'm
be
asking the
answered,
chairman to direct that the witness has answered the question.
but he has not answered.
3
the
times.
He hasn't.
Not once, 3 times.
But he has not, counsel. It is really quite simple. Generation plant is covered, generation plant is not covered. It doesn't have to have a cross-reference to T&D, and it doesn't have to have a cross-reference to deductibles.
Intervenor
So-
Watson?
no.
Yeah,
Sorry.
go ahead,
No, go ahead, Chair.
Mr. Blackman.
I didn't want to interrupt you. You go ahead.
Intervenor Watson, it is our intention that the witness have answered, and we would ask you if you could move along.
Mr. Chair, then can I ask that we accept that we will infer that generation plant, equipment buildings, and other contents of the buildings are not insured under the self-insurance fund, since nobody will just state that very plainly.
We would not be able to infer that.
Mr. Chairman, I must insist on a response to the question because it has not been answered. And it's really quite straightforward. That is a provision in the statute. It is explicit. It's not controversial. It
Chair,
should be very
we're getting
simple.
into a
Chair,
continued
kindly ask
problem
counsel not
of
to interrupt me as I
intervener
make
Watson
my
not accepting the orders
submission.
of this commission. You
Chair.
have ruled on this matter.
Chair.
It's not for further discussion.
Chair, kindly ask counsel not to interrupt my submission. I know counsel has taken to directing the chair. I'm simply trying to make my submission, and he can make his direction as he pleases, if you allow. The question is quite straightforward. It's a question, Chair, if I
No,
can
I just would
explain.
not want the comment that the council is directing the chair.
So you should tell him that, because that's what he's attempting to do.
No, but I'm just saying the accusation that he's attempting to do that just as how he wouldn't want you to attempt to
Withdrawn,
do that.
Mr. Chair.
Thank you.
What I would like counsel to not do is to interrupt me as I'm making my submission or putting questions to the witness. The witness.
We've
yes.
so noted and we've so ordered that we would wait. So all we were asking is if you could just move along with your questioning.
Right, Chair. What I'm saying in that respect, I understand your question. What I'm saying is that we're not satisfied that we are receiving. As a matter of fact, Chair, I shall do that. Mr. Blackman, is equipment and buildings, is equipment buildings covered under the self-insurance fund?
Yes.
Are other contents of the building covered under the self-insurance fund?
Yes.
Thank you, Mr. Blackman. See, that was painless. Can I ask about generation equipment again, plant again? Because that hasn't been answered. That's a
Again.
yes or no.
Fourth time.
But he was able to say yes to the others.
Well, Chair, we have a questioner directing how our answer must come.
Chair, that's
You can do both sides, you know, Chair. You don't need Mr. Blackman if you can give the answer and question. You can do both sides.
Chair, I will not point out the ironies of Council's comments. I'd like to proceed with my cross-examination.
Please continue.
Thank you. Mr. Blackman, let's look back at the issue of trustee responsibilities. You've said that you're familiar with the trust deed. Can you, Mr. Blackman, tell me, or tell us, the risks that are covered under the trust deed? The risks. By that I mean the catastrophe that is covered under the trust deed. Or the catastrophes that are covered, because they're multiple.
Yeah, originally it would have been restricted to natural catastrophes. However, it was amended sometime back to permit ISIF to cover losses which would otherwise be covered by commercial available and third-party insurance.
Can you delineate
Machinery
those?
breakdown, fire, you mentioned some of them a little earlier when you were questioning me, equipment, building, fires. So not just hurricane damage, for example. I couldn't rattle off all of them, but I know that it was expanded sometime back, 2005, I believe it was.
So your response is, you can list a few of them, but you can't list all of
I
the
would have to
list
pull
of
the
all
deed.
the
I can
catastrophes.
you have to reference the deed
Thank
and
you, Mr.
read it all for you, but
Thank you. Mr. Blackman, are you aware whether the Insurance Barbados Light and Power Company Limited Self-Insurance Fund Regulations 1998 have been amended since being passed into law?
yes, I believe there were, yes.
Are you aware of the specific amendments?
Can't recall. No, I would have to look back at them, but it was amended. I do recall.
Thank you. Mr. Blackman, let's talk a bit about your responsibilities as a trustee. Could you tell us, Mr. Blackman, whether the fund, is up to date on its reports to the Financial Services Commission?
Yes, to the best of my knowledge, it is.
Has the company provided those reports in answer to interrogatories submitted to the company?
Reports to the FSC, I believe we
Yes.
have.
You have. Is the trustees, required to submit any reports to the board of directors of the shareholder company?
The trustees, no, would give a report from time to time, but no.
I'm not
To
sure
the
that I
board.
understand your answer. Yes and no?
No.
No, you don't provide a report.
We don't provide.
Chair, the question was asked whether it was required, not whether
not
they
what it
do.
is that- yeah.
And it can be yes and no. We do it, it's not required.
Your answer is that you provide reports to the board of directors.
A verbal update would be provided from time to time. That's, to the best of my knowledge, what has been done over the past few years.
But to your knowledge,
Not
There
a
is
written report.
There's no
Yeah.
requirement for a written report as part of
As
the
far as-
trustee's requirements.
As far as I am aware, well, I'm reporting on what was actually done. I'm not aware of that being done in written form.
Thank you, Mr. Blackman. Mr. Blackman, on what regularity is the trust reviewed by the auditor of the fund?
It is audited annually as part of the annual audit of the financials of the fund, yeah. So annually,
And on what regularity is the type of assessment that you described before? For example, the CGM Gallagher. On what regularity is that form of assessment performed?
maybe 4 years, I would say. Every 3 or 4 years.
Every 3 or 4 years?
Yeah.
Yes. So you made reference to the assessment document that was relevant to the decision to,
In 2015
yes.
or 16.
Mr. Chair, I'd like to ask to have the assessment document relevant for the period between 2010 and to date, really. If there's only one, then that's what's to be provided. Otherwise, if there's more than one, can you say whether there's more than one assessment document?
There may be something around around 2010, but the one that I recall, because it was during my tenure, would have been in that period, 2015.
And there's been none subsequent to that?
No, there have been none subsequent to that. We're currently doing an assessment now, though.
Thank you. And the internal asset
Sorry,
management?
hold on, no. In the response, let me correct that. We would have provided, I believe in an interrogatory report subsequently done by a company called CoreLogic, which was 2018. So the one you referenced just now would have been 2015 or so, when the decision was made. An assessment was done in 2018, 3 years later, by a company called CoreLogic. As I mentioned, we're currently conducting, and I believe we shared the CoreLogic report as in a response to the interrogatory. We're currently conducting one now as well.
On what regularity are reports or reviews done by the internal asset management team?
In that same, when those assessments are done, the asset management team is involved in that assessment as well, or part of that process.
Do they produce a separate report?
No, they don't produce a separate report necessarily. In 2015, the one that we were referencing, there was a report in addition to the one done by CGM
Thank you.
or RMS.
Mr. Blackman, who are the members of the board of the Barbados Light and Power at present?
So at present, we don't miss anybody. Mr. Ian Carrington, Ms. Teresa Marshall, Sharon Christopher. The chair is Rick Janega. Myself. Who am I missing? Claudette Porter. So that's 6 so far. And I may be missing some others, but again, I can provide you with that.
Please do.
list.
Mr. Chairman, I think this would be an opportune time. It is past 4. So I am suggesting that we can adjourn today's proceedings at this time. I am not finished with cross-examination of the witness.
And how much
I'm
long?
just looking at the time. Oh, we have significant, because he does have wide responsibility,
Yes,
and there are many matters covered by the memoranda and affidavits filed by the witness, and we do have some other questions to put to him.
okay. Well, the time being 4:02 p.m. We will adjourn. Yes. We will adjourn to recommence tomorrow morning at 9 a.m.